Welcome to Economic Analysis in Employment Matters. Our presenter, economist George Jouganatos, has been a college lecturer for over 25 years. He has taught economics, finance, management, ethics, and quantitative analysis at University of California, Davis, University of California, Santa Cruz, California State University, Sacramento, and University of San Francisco. Dr. Jouganatos is in demand as an expert witness for cases involving personal injury, wrongful death, wrongful termination, employment discrimination, economic loss, business valuations, lost profits, and divorce. He has consulted and given testimony for numerous attorneys in California as well as in New York, Nevada, Iowa, Montana, British Columbia, New Mexico, Oregon, Pennsylvania, and Hawaii. He has consulted in approximately 700 cases and for more than 175 law firms. On many occasions, Dr. Jouganatos has provided commentaries on economic events and issues for television, radio, and print media. He is a member of the American Economics Association, Association for Evolutionary Economics, National Association of Forensic Economics, Sacramento County Bar Associate, and Friends of Mount Athos Society. His selected clients include California Department of Boating and Waterways, California Resources Agency, California Attorney General, California Department of Finance, California Department of Education, California Department of Transportation, California Department of Justice, California Department of Corrections, Governor's Office of Planning and Research, City of San Francisco, Harcourt Brace, McGraw-Hill, Delta Dental of California, Nationwide, General American Investments, Pacific Legal Foundation, and several financial institutions. Since 1991, he has worked as a consulting economist providing economic and statistical analysis for the private and public sectors. He has written many economic impact, efficiency, cost, and feasibility studies and has designed economic models, strategic plans, and performance measures. He has written and conducted seminars in the fields of the economics of development, political economy, economic history, environmental economics, public policy, operational analysis, and economic modeling and forecasting. Dr. Jouganatos conducted research at the University of Athens and the Center of Economic Research and Planning in Athens, Greece, where he conferred with many of the nation's top economists and political officials. The fruits of the research resulted in a seminal book on the development of the Greek economy. His work on the Greek economy has been cited numerous times. He also engaged in research at the Institute of Development Studies, University of Sussex. In 2000, he was awarded a Faculty Research Fellows Grant from the Center of California Studies, California State University, Sacramento, to analyze land holdings of the state for the Governor's Office of Planning and Research. He was awarded another Faculty Research Fellows Grant from the Center of California Studies, California State University, Sacramento, in 2012. This research, also for the Governor's Office of Planning and Research, involves assessing the implementation of California state planning priorities.
As for the calculations, historic loss, or often it's referred to as back pay, is really the period in time from the incident to date of trial. And we would use wage growth rates often to adjust for the wages from the time of incident to the time of trial, but it's not always done, but we could do it. Now, this would involve perhaps adjustment for promotions. This is permitted, lost chance damages. So back pay may be increased to take into account promotions the employee was likely to have received. I provide you some case law regarding this. The next calculation would be the present value of future loss. Often it's referred to as front pay. Now, it's part of the legal standard to discount future dollars to present day terms. For instance, a dollar in the future has a lower value today, and that's what we are computing. I'd like to give you now some non-litigation examples of what we call the time value of money in the field of finance. Some might refer to it as money value of time as being more intuitive expression, but usually it's time value of money. Let me give you an example of a use of this present value calculation. This would involve, for instance, you get fortunate, you become fortunate and you win the lottery. Suppose you are awarded, so you think, $1 million. You win the lottery of $1 million and you're pushing your wheelbarrow to the lottery office in the expectation of collecting. They tell you, get out of here. We're not going to give you the $1 million. You have two options. We'll give you option A, $50,000 a year for 20 years, or option B, the present value of option A, the present value of $50,000 a year for 20 years. That present value would be paid to you in a lump sum. So using that example of winning $1 million in the lottery and option A, which is $50,000 a year for 20 years, the present value of that, when we're incorporating an interest rate of 5%, the interest rate involved in present value calculations is referred to as the discount rate. It's simply the interest rate, the name of the interest rate we use when we're computing future values to present day terms. Now, this amount, if we are saying the interest rate or discount rate is 5%, this amount that you would settle for is $623,000 and some change. So again, the present value of option A, which again, to reiterate, option A being $50,000 a year for 20 years, given a 5% interest rate or discount rate, is $623,000. This is equivalent to earning $50,000 a year for 20 years. Now, if we were to increase the interest rate or discount rate to 8%, that amount that you would settle for, the lump sum amount, would lower to $490,000, almost $491,000. So as you can see, if we were to increase the discount rate, the present value is lowered. This is somewhat useful to you in your work. If we were to increase the discount rate to 3%, then the present value of $50,000 a year for 20 years using a 3% discount rate or interest rate is almost $744,000. So once again, this $744,000 is equivalent to receiving $50,000 a year for 20 years. This is referred to in finance literature as the present value of a future annuity, annuity meaning annual payment you are receiving. It could also work for an annual payment you are making. Now, let's give you another example, a present value of a lump sum. present value of a lump sum potentially paid to you. Suppose you have a wealthy uncle who is fond of you and tells you that in 20 years' time, he will give you $1 million. Of course, you're anxious for it, and you're not that willing to wait for so long. So you tell your wonderful uncle that you are willing to accept the present value of that amount, $1 million, paid to you in 20 years' time. So this calculation would be referred to as the present value of a future lump sum. Now, if we are using a 5% interest rate again, then you would be willing to settle for approximately $377,000. So the $377,000 is equivalent to today to receiving $1 million in 20 years' time. Now, the presumption is in these examples that you would invest these amounts, these payments to you, the lump sum payments, into a financial instrument earning 5%, and that at the end of the time period, 20 years, you would have that $1 million in both examples that I gave. Of course, now we can move on to a litigation example. And this example for now would be a personal injury example. Okay. Suppose you're driving and you're using your cell phone and you injure someone. You injure the other driver. You bump into them. That other driver is no longer able to work. That's the claim. And according to the work-life tables, which I would discuss later, this driver you injured had 20 years remaining of work life. Okay. Now, suppose the driver you injured, annual compensation is $50,000 a year at the time of the accident. And if we're assuming a wage growth rate of 3% annually and a discount rate of 5%, then how much should you settle for? If, again, in terms of these damages and not pain and suffering, just the economic loss damages, well, that amount would come out to $817,572, $817,572. So now I provided to you an example of present value calculations for not just the lottery and your wealthy uncle, but for litigation purposes. So again, the notion is that this lump sum payment today is equal to a stream of future compensation. It assumes that this lump sum is used to purchase some sort of financial instruments that will generate returns in an amount close or approximately equal to the total future compensation you lost out on. Now, according to certain case law and to FIHA, this loss could extend for the remainder of work life. I give you some case law in the outline, Behoon versus AT&T, as well as Williams versus Pharmacia, so that this economic loss could extend for the remainder of work life. Now, the main components. So work life is a statistical average of the number of years a person will be working. It factors out the probability of death, sickness, child rearing, and just leaving the labor force for other reasons, such as being disgusted, you need a break, that sort of thing. Now, generally speaking, the work-life expectancy tables that were authored by the Bureau of Labor Statistics, United States government, were considered the most authoritative, but they are out of date. I believe 1986 was the most recent. Instead, we have a few other authoritative work-life tables that are more current, and BLS data is used to arrive at work-life tables. Okay. For instance, the work-life table that I've been using for the last many years, I cite to you in my outline. It comes from the Journal of Forensic Economics. This work-life table would be considered then peer-reviewed and authoritative. And I give you the citation in the outline. The authors are Hunt, Pickersgill, and Root-Miller. It appears that the few existing authoritative work-life tables yield rather similar results. Let's move on now to the discount rate. As you've already learned in my earlier numerical example, the higher the discount rate, the lower the present value. I use in the outline the term net discount rate. The term net discount rate simply is a shortcut. Well, the net discount rate that I give you is the discount rate minus the wage growth rate. That itself is a bit of a shortcut and easier to understand for jury and clients themselves. It's a useful shortcut. So it's really the net discount rate that we are most concerned with. Again, the net discount rate is the discount rate minus the wage growth rate. Now, the discount rate that I use for many years now, I use a long-term average, roughly 20 years. What I give you in the outline is, in fact, a 20-year average rates from various treasuries. So, for instance, I'm using a 3-month Treasury bill rate, 6-month Treasury bill rate, 12-month Treasury bill rate, as well as 3-year Treasuries, 7-year, and 10-year Treasuries. The average of these is 3.629. Now, I believe that this would be considered truly the risk-free rate of return. Legal standard and case law suggests strongly that in employment cases, personal injury cases, and wrongful death cases, we use a risk-free rate. Okay. Using these short-term securities, well, the short-term would be the Treasury bills. In recent years, I added the long-term Treasuries because in the last few years, Treasury bills, the yield is minuscule. So to be fair, I've added long-term Treasuries, and other economists may use long-term Treasuries too. But ultimately, during other economic times, not our difficult economic times that we've been facing recently, but prior to that, I was using strictly short-term treasuries. Short-term treasury securities is justified to remove any inflation risk that might appear in using long-term treasuries. It's not always financially prudent to lock into a treasury bond when future interest rates are expected to rise. I added in my outline for you that for a few months in 2005 through 2006, we actually had long-term rates, long-term treasury rates below the short-term rates. And this is very unusual. When this happens, we say in finance, and it makes the news in the Wall Street Journal, et cetera, that we have a inverted yield curve. The reason for this inverted yield curve, meaning long-term interest rates fall below short-term interest rates, treasury interest rates that is that the market is expecting a business or economic slowdown. And sure enough, we did have that in beginning late 2008. Now, typically, the longer the maturity of these treasuries, the higher the yield. Okay. And this is simply an economic principle of foregoing liquidity, but we didn't want to get into too deep of an issue now on this. Often we may see that there is debate regarding the discount rate to be used. I term this as the controversy surrounding the selection of the net discount rate. Really, this controversy or debate is much ado about nothing. And we need to really focus on the net discount rate. The net discount rate, once again, is the discount rate minus the wage growth rate. There is no set method for ascertaining the appropriate discount rate. And indeed, the parties are normally given a great leeway in arguing what the discount rate might be. Okay, and I give you a little bit of case law about that. There's, in terms of burden of proof, no known reported California decision has squarely resolved which side has the burden of proof regarding the appropriate reduction to present value. And that seems pretty clear from my experience. I provide you then numerous articles in support of the discount rate, articles from peer-reviewed journal. The journal is the National Association of Forensic Economics, peer-reviewed journal of Forensic Economics, and that provides support for the use of the discount rate that I'm using here, including the discussion on short-term rates. In these articles, I summarize for you. It's clear that the discount rate should be a default risk rate, and this implies treasuries. Even treasury bonds would fall into this. The discount rate should also be inflation risk-free rate, and this would imply short-term rates such as treasury bills. The discount rate could be a tax-free rate, and this would imply a treasury rate minus some effective average marginal tax rate, or you could use a low-risk municipal bond yield for this. Finally, the discount rate should be an average over some reasonable time period. Okay. I use, again, a longer term, such as 20 years. This reduces the fluctuation in both the discount rate and, as you will see, the wage growth rate. And I will talk about that shortly. So again, many authors do discuss averaging. Okay, and this averaging should be, for the discount rate, should be identical to the earnings growth period that we're averaging as well. So I use 1994 to 2013. I provide a little bit more case law regarding discussion of the discount rate. Now let's move on to the wage growth rate. The higher the growth rate, wage growth rate, the higher the present value of future earnings. I typically use a historic 20-year national average growth rate of some type of wage, such as private sector non-agricultural wage or public sector wage. This is published by the Bureau of Labor Statistics, United States government, so it's authoritative. Currently, I use 2.83 as the private sector non-agricultural wage average growth rate for that period, 1994 to 2013. For the public sector, it's 2.625 for that same period of time. You might be asking, why not use past average growth rate of the plaintiff? Well, the information may not be fully available. We may have just a couple of years of earnings available at this particular employer, or the future, we might consider it to be too uncertain, or the individual may have entered another occupation, or this might be considered at least. Again, often enough data is not available regarding earnings history and wage growth, actual wage growth. So I typically then use national averages. I duly note in my report or in testimony that a more conservative number is being used if, for instance, the plaintiff wage growth was higher in actual fact than the average that I'm using. Okay, the average from the national data level. Okay, again from the BLS. If I have what I consider to be a good amount of reliable salary history with the same employer, then I would prefer to use the actual earnings growth, of course. You might ask, since some case law may have discussed the inflation rate. Well, how come the inflation rate, as given by the Consumer Price Index, is not used by me? And maybe by others as well. The unfortunate reality is that for the average American, wage growth has not been keeping up with inflation since approximately 1975. You hear about the difficulties the middle class has been facing. This is part of it. We refer to this phenomenon as the falling real wage. So using the inflation rate, therefore, may overstate the loss, not necessarily, but may. More importantly, using this wage growth rate might be more astute. Okay. Currently, the wage growth rate that I use is very close to the inflation rate, just so you know. If it turns out that the wage growth rate is quite a bit more conservative than the inflation rate, which it is not the case currently, and then I would duly note it in my report or in testimony. So once again, as even a colleague, opposing expert, found that using the wage growth rate is more astute and more accurate. So again, case law does suggest that we need to factor in growth of wages or inflation. Now, what might be the salary base to use in this analysis? And again, I cite from the Journal of Forensic Economics, and I give you that citation in the outline. Now, what really is of issue, especially in personal injury cases, is the lost or diminished earnings capacity, but it's an issue in employment cases as well. Now, for the average worker, again, we're trying to determine the earnings capacity, and that would be used as the salary base. For the average worker, past earnings history remains the most important source of factual information for earnings capacity. And this earnings data is likely to have an impact on the eventual compensation award. Now, what I wanted to add is there's strong evidence of what would be capable of earning in the future. In other words, this past data gives us strong evidence of what the plaintiff could be earning in the future. So actual earnings data is often the starting point for measuring earnings capacity. And if there's no information to the contrary, it's usually assumed that actual earnings demonstrate earnings capacity. There's a lot of literature in forensic economics about this issue. And in a survey of forensic economists, we use historic earnings or earnings history as a starting point. And it could be our ending point too. It all depends on the issues of the case. So this notion is bolstered by even another peer-reviewed publication in the journal Litigation Economics Digest, so that we forensic economists look to specific earnings history of the individual when available, and we exercise judgment in determining the earnings capacity that should be expected in future years. Generally, there's not an issue in employment cases, but in personal injury, it might be more of an issue. Let's move on now to other issues. The first that comes up would be the pension. Lost pension and other deferred compensation benefits are recoverable as back pay. Okay. And I give you some citation, case law citation for this. Also, I mention both from case law and forensic economics literature, there's no widespread consensus on how to calculate lost pension benefits. There's really two general approaches. One is to count as loss the employer contribution to pension. That's rather straightforward and simple. Another approach, and according to many in the forensic economics area and from literature that I've reviewed, perhaps the best approach would be to compare the reduction in the payout at time of retirement rather than employer contribution. So we have a wrongful termination and the pension has been impacted. The perhaps more accurate approach might be to look at the reduction in pension payout as a result of this wrongful termination. But there are going to be some arguments against this calculation, and that would focus on the assumptions. You have to make assumptions when you're computing the diminished payout at the time of, let me rephrase, the diminished pension payout at the time of retirement. And the one assumption would be, what would be the growth in salary? You take an early retirement because of wrongful termination, you're vested, and the plaintiff takes an early retirement, but would have worked another 10 years. So in that 10 years' time, surely that client of yours, the plaintiff, would have received some salary increases. Now, what that salary increase would be is uncertain, so we have to make certain assumptions. We could look at past salary increases, or we could use national averages. Once again, the other side would may find fault in this assumption. Isn't it true that the wage growth rate you're using might actually be lower? Now, another assumption that could be criticized would be the formula. Isn't it possible that the formula would change, the payout formula? That is unlikely, but the other side may bring that up. Either way, you may have some criticism regarding the use of assumptions in looking at the present value of diminished pension payout at the time of retirement. Okay, that it might be a bit speculative. However, it's more time consuming, this approach. That's the other consideration. Okay. Let's move on now to other issues such as health benefits. Health benefits, dental, vision, medical, need to be considered as part of the loss. Ideally, we'd like to use the employer contribution to these benefits. But often that information is not available. At least it's not made available, too difficult to obtain. So then we can use national averages. I give you a citation of which national average, or I should say, which source I use, and that would be United States Department of Labor, Bureau of Labor Statistics, employer cost per hour. The latest, I believe, is September 2009. There might be something more recent. And as an example, the national average non-legally required benefits as a percent of salary for a professional employee in the public sector is 27.1%. Okay, that does not include Social Security, Medicare, etc. This figure includes paid leave, supplemental pay, insurance, and retirement. So we could use, again, there's tables of data. I just gave you one selection. And we could use private sector information from this source or public sector information. Of course, again, the ideal is to use the plaintiff's employer contribution. Another method is if the plaintiff found or is paying for health insurance on their own, this would be considered replacement cost. This information can be used in lieu of employer paid. In other words, in the unlikely event the plaintiff is able to afford health insurance on their own, we could use that information. And I give you case law in support of this. So it's not merely the amount it would have cost the employer to provide such coverage, but the replacement cost. Now, going back to employer contribution to these benefits, what needs to be deducted is the savings of the employee, the plaintiff. Suppose the employer pays $1,000 a month towards these benefits. The employee pays $100 a month. That $100 must be subtracted from the loss because now that employee is saving that money. So again, we're looking at the net value of employer paid benefits. Often the COBRA sign-up forms, if it exists, would have this information. Okay, let's move on now to Social Security issues. It appears, according to case law and forensic economics literature, that it's rather inappropriate to consider Social Security as a potential loss in employment matters. It's less clear for personal injury matters. And I give you numerous citations regarding peer-reviewed forensic economic literature in support of eliminating Social Security as a form of loss, a category of loss in employment cases. Also, personal injury cases are discussed in this literature too. Then I give you several citations of case law, and I leave it up to you to review the legal arguments for not including Social Security as a loss. Now, if the expert by mistake brings up Social Security as a potential loss, then what the opponent can bring up is Social Security disability payments can be deducted now. So once again, if the plaintiff's expert brings up Social Security as a category of loss, the defense can now bring up as a deduction disability payments if they were awarded. So in other words, disability payments must be deducted from this category that was inappropriately brought up by the plaintiff. One economic argument, just in case you were curious, regarding why Social Security is not a loss, but I ask you to look at the legal arguments in those case law that I brought up, is that the plaintiff is no longer receiving, being that the plaintiff is unemployed, is no longer receiving the contribution from the employer to Social Security. And that is offset by the fact that the employee is now no longer contributing to Social Security. Okay, this is a economic argument. There's other economic arguments as to why Social Security is not considered a loss in the review of the literature. We'll move on now to other issues unused vacation. Case law permits that unused vacation time is recoverable as back pay and even as front pay. Back pay, I refer to it as historic loss. Front pay, I refer to it as present value of future loss. In case I neglected to tell you the demarcation between back pay and front pay, or historic loss and future loss, that point of demarcation really is the date of trial. Okay, when the date of trial would be the point that future loss begins. If there isn't a trial date, then I may use a settlement conference date or a mediation date. Anyhow, I do provide you a discussion regarding the unused vacation as a category of loss. And this unused vacation is non forfeitable, and California law prohibits California employers from enforcing a use it or lose it vacation policy. So you cannot forfeit your unused vacation time. So once again, loss of future earnings or front pay damages may include, in addition to back pay, an award of salary and benefits wrongfully discharged plaintiff would have earned from the employment after the time of trial. And we give you case law in support of this. Now let's move on to another issue, important issue, mitigation of loss. Suppose even during historic loss period, as well as future loss, the plaintiff has sought out and become employed again. Well, this is not a difficult issue for the economist in this, the forensic economist, but we need to subtract all earnings from employment from the historic loss period and future loss period, if the plaintiff has been employed in alternate employment. Okay, it could very well be that the back pay or historic loss, the plaintiff has not become reemployed, even though he or she may have sought properly to mitigate losses and sought out employment. If I understand correctly, case law states that it is up to the defense to show that the plaintiff did not properly mitigate. At any rate, once again, I mentioned some case law that even if this plaintiff has re-entered employment, there could be a differential. The plaintiff was earning $80,000 a year in total compensation. Now the plaintiff is earning $50,000 a year in total compensation. When I say total compensation, that's both wages and benefits. Again, not only the non-legally required benefits. So we're looking now at a differential of $30,000 per year. $80,000 was his or her previous total compensation annually. Now it's $50,000. So we're looking at a $30,000 differential, and we could extend that for the remainder of work life. And that's what I am saying, according to some of the case law in the outline, that we can extend this differential in total compensation for the remainder of work life. Then I discuss collateral source. Perhaps a seminal case in California is the Hellfund versus Southern California Rapid Transit District, and I give you the citation. That and some other case law outlines, and you might have a far more extensive and up-to-date database on collateral source, but It's important for forensic economists to know what sources of income are not permitted as a deduction from the loss. So even pension might be considered a collateral source. The plaintiff takes early pension, early retirement, and receives a pension. This may be considered a collateral source under some case law. Moving right along now, let's discuss taxes. I mentioned, for instance, that there is case law where the plaintiff is not required to produce personal tax returns, and future income tax consequences are not admissible according to case law in California. I provide some of that. But an important issue that I do want to bring up is that the fact that this lump sum award or settlement may have potentially adverse tax consequences. The tax on the lump sum of $1 million, as an example, is going to be a lot more than a tax that the plaintiff would have paid on $50,000 a year for 20 years. So there's been some work in forensic economics literature to account for the adverse tax consequences of a lump sum award. Now, it appears, though, some courts may find this computation of adverse tax consequences to be speculative and inadmissible. Certainly, the computation involved would require several hours of work. But again, as I indicated in, I believe it was an appellate court in California, that this computation of adverse tax consequences was inadmissible, but there might have been, there are other cases where it was admissible. I understand, of course, there are some mechanisms that can be employed to reduce the tax burden of a lump sum payment. Moving on now to another topic, punitive damages. In some cases, the punitive damages might be permitted, and the forensic economist can certainly help you with that. It would come down to evaluating the financial health of the employer. Often that would involve examining financial statements, computing financial ratios and analyzing them. This would be very simple to do if the company was a publicly held company. It's a little bit more time consuming for the forensic economist or financial expert if the company was privately held or closely held. Another issue that would be important to evaluate, and that would be the business valuation. What is the value of this business? That might be quite important in the formulation of punitive damages. So it's not just the financial health of the company, but what is the company's worth? That gets into another field in forensic economics or forensic financial analysis, and I do have another program for that. However, it might require, if it's a publicly held company, it would require a few hours of work to arrive at what we call the enterprise value or business value of the company. If it's a closely held company or privately held company, the number of hours would be significantly more. At any rate, we can save that discussion for another program. Well, that concludes the subject matter of economic analysis and employment cases. Just to review what I've covered, I began by discussing historic loss or back pay as the period in time from the incident or date of termination to the date of trial. And I discussed the types of losses involved in historic loss, components of loss, that is, in back pay. Then I began discussing present value of future loss, and I took the liberty of sharing with you non-litigation uses of present value. You might recall the lottery and the wealthy uncle. The notion behind all of this is that this is a principle in finance, time value of money, and it's really 15 billion years old. What do you mean by that? Well, all scientific laws and mathematical laws of the universe were created at the point of the Big Bang, and this is a mathematical property, mathematical financial law, time value of money, and it has to be employed in consideration of future losses, where we're talking about future losses stemming from employment cases, personal injury cases, wrongful death cases, or business cases. Now, this loss could extend for the remainder of work life. I defined for you what work life is. It considers a number of factors. Of course, work life must be discussed in the report or in testimony, but the expert could provide an alternative scenario, such as, okay, this person in this alternative scenario would retire at age 70, which may exceed the work life expectation. Again, the work life is a national statistical national average. So it's reasonable, perhaps, in some scenarios to include an alternative. Then I got into more deeply the discount rate and the net discount rate and what should be used. The net discount rate is the discount rate minus the wage growth rate. I discussed the reasons why I use the wage growth rate rather than the inflation rate, even though they're very close. The numerical values are very close at this time in this historic period that I use, the 20-year historic period. I provide case law as well as forensic economic literature regarding my use of this net discount rate. Then we got into other discussions, such as salary base, pension loss, which is very important to discuss and thoroughly analyze, and then the loss of medical or health benefits. Okay, and I gave you approaches to analyzing those losses. I discussed then Social Security as inappropriate in employment cases. So loss of any consideration of Social Security would be inappropriate in employment cases. Then we discussed mitigation of loss. So the person's back to work, but we're looking at the differential between what that person was working, what was receiving at the former position compared to now, compared to their present position. And then we discuss punitive damages. If you have any questions or even case-specific questions that you may have regarding what you're working on currently, please don't be hesitant in contacting me. You have my contact information. It's George A. Jouganatos. I'm based in Sacramento, but I take on cases all over California and other states. My address is 2001 T Street, Sacramento 95811. Telephone is 916-739-1132. My email is george@Jouganatos, Jouganatos. It's spelled the way it sounds, And my web address is www.jouganatos.com. I hope you found a lot of useful information in today's seminar, and I'm grateful that you've attended. Thank you.